Well, thank you. It's my pleasure to be here to provide a little information about how interstate water conflicts are resolved. There are basically three main methods that water apportionments or water conflicts can be resolved among states. These aren't only in the western part of the United States. There are compacts throughout river basins across the United States. The three ways that states can allocate water between themselves where there are interstate river basins are either by congressional action, by interstate compact, or by the U.S. Supreme Court. So this is important because in Western or in law across the U.S., states have primacy on the waters that flow within their state boundaries. So the state lines really mean something when it comes to the management of water supplies. The two main differences between how waters are allocated between the states, one is by compact and one is by decree. Compacts are when the states can agree and reach some sort of settlement between themselves, and then that compact is ratified by Congress. Decrees are essentially when the states couldn't agree, and litigation is held almost always in front of the U.S. Supreme Court. Congressional equitable apportionments are an option, but they are quite rare. I do work for the Wyoming State Engineer's Office. I've been working on interstate activities for about 26 years. Just wanted to put up a map showing where Wyoming lies in the West. We are a headwater state. And as you can see from this map, we do participate in most of the major river basins of the West. Before I get into some specific examples, Wyoming is party to 7 different interstate compacts and 2 U.S. Supreme Court decrees. One of those Supreme Court decrees was actually one of the earliest allocations among the states, and that was on the Laramie River that we share between ourselves and the state of Colorado, and that was a Supreme Court action back in 1922. Most of the negotiations, either for developing interstate compacts or the litigation, was held somewhere between the 1920s and the 1950s. In most of our agreements, the water rights that are in place, I think you've heard about the prior appropriation doctrine. So our permits that the state have issued for beneficial use of water, those water rights are recognized as of a specified date that's generally detailed out in the compact or the court decree. And then any water that's considered over and above what those water rights were then allocated between the member states. Those allocations can be done sometimes on a percentage basis, or sometimes they're based on firm values or firm numbers, perhaps at a stream gauge. And generally there's some type of river basin commission or some other institution that's put in place on providing some logistics of how the states will participate and assure that the states are living up to the agreements. So this map shows the various compacts and decrees that Wyoming is party to. Since we have limited time today, I'm really just going to concentrate on 2. The first being the Bear River down in the southwestern part of the state, and that river basin we share with Idaho and Utah. And the second is the Yellowstone River Compact. That's a single compact that covers 4 main tributaries that flow northward out of Wyoming and flow into Montana. So let's start with the Bear River Compact. It's unique in a few ways. The first is that it's our only compact that has been amended. It's also unique in the number of times the Bear River crosses state line boundaries. It originates in Utah, flows into Wyoming, flows back into Utah, flows into Wyoming, goes into Idaho, before eventually dumping into the Great Salt Lake. So with all of these multiple river basin crossings, each state has to have some assurance of how much of the river basin is under their authority to allocate. It is also unique in that there are no federal storage facilities, either from the U.S. Bureau of Reclamation or the Corps of Engineers. The compact actually describes how these water emergencies, which is defined in the compact, and again, you have heard about the prior appropriation doctrine, which is how each state will determine which of their water rights are available to get water at any given time. You can think about this water emergency of the compact of being an additional layer of administration. So there is staff that works for the commission, and they let each state know how much water they can have out in their respective states at any given time. Each of our 3 states have field personnel who then go to each of the diversions or the head gates and determine whether we are in compliance with those amounts of water that the River Basin Commission engineer manager has told us that we can have out during any given week. The commission in the Bear River is made up of 3 governor-appointed people from each of the states, so that would be 9, 3 from each state, plus 1 federal chairman who has non-voting status. I mentioned this was our only compact to have been amended. It was amended to allow some additional storage and additional depletions or additional use in the upper basin states. The second river basin compact that I would like to talk about briefly is the Yellowstone Compact. This is a compact that we share with Montana, although the state of North Dakota did also sign, but they are really a very minor player. I think the Yellowstone is a nice example of a compact. So again, an agreement where the states did come to agree on the provisions that are in the compact. But because the state of Montana felt that Wyoming was not living up to the provisions of that compact, they actually brought litigation against the state of Wyoming. So back in 2007, the state of Montana sued the state of Wyoming. Since it's 2 states suing each other, then the U.S. Supreme Court is the court of original jurisdiction. As I mentioned, the Yellowstone Compact covers 4 main tributaries, but the Montana litigation eventually wound up just covering one of those compacts, the Tongue River. The U.S. Supreme Court, in these types of very detailed and very difficult court cases, will generally name a special master. That special master then has the authority to hear the evidence. In our particular example here, we actually held trial for over 2 months, where experts on both sides are then brought before the special master and questioned by our legal counsel to provide evidence on why we believe, in Wyoming's case, we did not violate the compact. There are many examples of these interstate litigations, many of which have gone on for 20 or 30 years. So we are somewhat the exception in having only been going on since 2007 and till now in 2014. So each of the parties, so the state of Montana and the state of Wyoming, will then be given the opportunity to tell the Supreme Court why we feel the special master either was right or not right. And then we're probably looking at least another year before a final decision will be made. Again, I think the interesting intersection of both types of ways of allocating water come into play here, in that once the Supreme Court issues their ruling, then it will be up to the Compact Commission that was put in place by the Compact to then decide how to instigate or put into place the rulings that the U.S. Supreme Court makes. So with that, I hope you'll feel like this was a quick journey into interstate activities and how amongst our states we do allocate waters, and that there are provisions for resolving issues when one or more states feels like they have not been lived up to the provisions of the compact by another state. Thank you.